This is speaking for Claim School Incorporated with another true crime story of insurance fraud. This one, number 28, is about the too honest jeweler. The jeweler had learned to cut diamonds in Antwerp. For 10 years, he worked in a small office, grinding facets onto stones of half a carat or less. The boredom of the job infuriated him. He had no future. He decided to immigrate to the United States, where he could use his skills. He turned his savings into small diamonds, which he purchased below wholesale from the marketplace in Antwerp. He started business immediately upon arrival in the United States, trading diamonds in the Los Angeles wholesale market. His knowledge as a cutter allowed him to make profitable trades and sales. He came to the United States on a tourist visa. He knew that the only way he could become a legal permanent resident was to have a business in place. The income he derived from his sales was sufficient to allow him to live in Southern California, but not set up a business. He needed a large influx of cash. After only a month working the wholesale jewelry market, the jeweler learned about insurance. It seemed to him that when they weren't talking about gems, all jewelers ever spoke about was insurance. It was expensive. The insurers required them to install sophisticated alarm systems. The insurers required them to install safes that far exceeded any need of reasonable security. Other, less honest jewelers used the insurance company to make a bad year into a good year. Cheating an insurance company, they explained, is simple. The insurance company would accept whatever books and records a jeweler gave them, thus not marking sold on an item in an inventory book. He could sell a gem twice. First, it is sold to the customer. Second, when the jeweler reports a loss, robbery, or burglary, it is sold to the insurance company, since it is still noted in the inventory as being present to steal. The jeweler saw insurance as a way of setting up a permanent business and becoming a legal resident of the United States. He got from his jeweler acquaintances the name of an insurance broker who asked few questions. He contacted that broker and told him that he was a diamond salesman who operated his business from his home. The broker presented an application to underwriters at Lloyd's, London, since no American market would accept such a risk. The underwriters at Lloyd's refused to insure the jeweler because he had insufficient security in his apartment. The jeweler was undaunted. He went to another insurance broker. This time he described his business premises as the location of one of his acquaintances. He put on the new application the address of the acquaintance and the type of safe at the acquaintance's premises, the type of alarm system, and all other security devices on the premises. The jeweler described his inventory as $100,000 in loose diamonds. The jeweler knew, but did not disclose to the insurer at the time he bought the policy, that his inventory consisted of many very small diamonds whose values totaled no more than $10,000. He created an inventory book describing $100,000 in diamonds by merely placing 1 or 2 zeros after the total carat weight of the diamonds he had in inventory. The broker submitted the proposal to 3 insurers, including RLI Insurance, Chubb Insurance, and Protection and Indemnity Company of Puerto Rico, who was the only insurer willing to insure him. He was pleased to accept that policy. 1 month later, he reported to Jewelers and Protection that he had been the victim of an armed robbery. He had an appointment with a retail jeweler in Cerritos, California, to show his loose diamonds. The jeweler arrived early and stopped at the local Denny's to have lunch before his meeting. He had all of his inventory in a small leather pouch in his inside coat pocket. It was a warm spring afternoon, and when he pulled into the parking lot of Denny's, his window was rolled down. As he turned off his engine, he looked to his left and saw a black man holding a chrome-plated pistol, and the pistol was pointed at the jeweler's mouth. The black man demanded his wallet. The insured, of course, complied. The man instructed the jeweler to put his hand on the dash and his face on the steering wheel. Frightened, he did as he was told. The black man then reached into the window and struck him across the forehead on the right side of his skull with the pistol. The jeweler was unconscious for a short time and awoke with his head slumped against the steering wheel. The thief must have reached into his coat pocket because the pouch containing the diamonds was gone. The loss, of course, was highly suspicious. The insurer's adjuster noted multiple red flags or indicators of insurance fraud, including the fact that the loss occurred shortly after the policy was issued, that it happened in a way that appeared to be physically impossible because the bruise was on the right side of the jeweler's head, and it would have required the armed robber to have reached in across the insured's face and then doubled back with his pistol to strike him as described. The insurer retained counsel to examine the jeweler under oath, and the jeweler, on the recommendation of his insurance broker, retained another attorney to represent his own interests. Counsel for the insured became quite bored with the proceedings. The insurer's attorney, being familiar with the intricacies of jeweler's block policies and the warranties made by an insured when purchasing a jeweler's block policy, inquired in copious detail about each statement made in the proposal for the jeweler's block insurance. The insured responded to each question thoroughly. The insured delayed his responses, however, because of the need for a French language interpreter that allowed him to hear each question twice, once in English and then again in French. The insured's counsel, well over 60 years of age, could take it no longer. He fell asleep on the sofa in the office of the attorney for the insurer. When the fact was pointed out to the jeweler, he said, "Go ahead, it doesn't matter if he sleeps. Let him enjoy his time." So while the insured's counsel slept, the insured admitted that he had operated his business from his home, that he did not have an alarm system in the home, and that he did not have a safe in the home. Rather, it was the business location of a friend who would occasionally let him store his inventory in the friend's safe. Counsel asked, when faced with those truthful responses, why the insured had listed a business address for his jewelry business, when in fact he had none. The jeweler explained, "When I honestly reported my business arrangements, I was refused insurance by Lloyd's of London." Counsel for the insurance company completed the examination under oath shortly thereafter. He awakened counsel for the insured and wished them a good day. Counsel then advised Jewelers Protection and Indemnity Company of Puerto Rico to immediately rescind the policy of insurance for willful material breaches of warranty and misrepresentation of material fact. The testimony by the jeweler clearly established that the jeweler knew that he was not eligible for insurance with anyone, including even Lloyd's underwriters, who would almost insure anyone if the premium was right. The jeweler intentionally and willfully misrepresented the state of his business and security to get the insurance. There was never an honest and honorable agreement between the insured and the insurer about the risk the insurer was asked to take. The policy was obtained without question, counsel advised, by fraud. The insurer agreed, and counsel advised the insured's attorney of the rescission. Counsel referred the attorney for the insured to the line and page number of the transcript of the examination under oath, where the jeweler admitted to misrepresentation on the proposal form. The jeweler met with his lawyer to discuss his future actions. He could not understand why he did not recover $100,000 from his insurance company like his friends had advised. The insured's lawyer, although drowsy, was familiar with the law. He had no intention of becoming a party to a fraud. He explained to the jeweler what he had done, even if done without malice, was sufficient to allow the insurance company to rescind the policy and treat it as if it had never existed. The lawyer explained to the jeweler that his actions were not only wrong civilly, but in California, an attempt to defraud an insurer was also a criminal offense. If the jeweler was not careful, he might be arrested and spend 5 years in the state penitentiary. He could also be shipped out of the country as an undesirable alien. The lawyer suggested that the jeweler leave well enough alone. The insurance company seemed willing to close out their books without payment and not pursue criminal prosecution. If he upset them, he might find himself facing criminal charges. Finally, because the lawyer knew of the fraud, he made it clear to the insured that he refused to sue the jeweler or participate in any way in the jeweler's fraud. The jeweler's attempted fraud could have been successful. His mistake was not knowing enough insurance law. His mistake was giving the lawyer for the insurance company facts that enabled the insurance company to rescind the policy. His mistake was allowing his lawyer, who could have protected him, to sleep while the questions were being asked. To be a competent and effective as a perpetrator of insurance fraud, it's necessary to know when to lie and when to tell the truth. The jeweler did not know. He told the truth when he should have lied, and he lied when he should have told the truth. Luckily, he was not arrested. Luckily, no insurance fraud investigator was interested in prosecuting him. And he went on to try to be a jewelry salesman and stay in the United States, overstaying his visa because nobody really cared. This video was adapted from my book, Insurance Fraud Costs Everyone, which is available as both a Kindle book and a paperback from Amazon.com, as well as my book, Insurance Fraud, in 2 volumes, also available as Kindle books and paperbacks. Thank you for your attention.